Yeah, yes, Mr. Mshololo.
Thank you, my Lord. My Lord, firstly, I would like to respond to paragraph 11 of the submissions made by the state in the heads of arguments,
okay.
my Lord. Yes. Which says, my Lord, it's paragraph 11.
Yeah, okay.
Yes. It says, at issue in these proceedings will be for the court to determine whether the prerequisites of Section 217 of Act 51 of 1977 have been met, whether the state has acquitted itself of the honors to show that accused number 2 has made a statement as per Exhibit JJ, and if so, whether he did so freely and voluntarily. My response, my Lord, to that, and I would like to draw this court to the attention of the case of S versus Magwaza. My Lord, I'm reading it from
Yeah, I've got the case of Magwaza here.
Yes, Magwaza.
Yeah.
2016, Volume 1, SACR 53 in bracket SCA.
Okay.
Where the trial court and the full court focused solely on the voluntariness of the pointing outs and confessions. Both were criticized for not touching even tangentially on the Constitution's exclusionary provisions, Section 35(5), my Lord, applicable in this case. Where there was certain reason to do so, the right of an accused to be informed of his rights and the consequences of an infringement of this right.
Yes.
My submission, my Lord, is that we are in a trial within a trial in respect of Exhibit JJ.
Yes.
And the content of the statement has been blocked before this court. Yes. That content has not been revealed yet.
Yes.
And we have agreed to block in the incriminating statements or words in the document which has been submitted before this court.
Right.
Until the ruling whether the statement is ruled admissible or not by this honorable court.
Yeah.
My submissions, my Lord, is that the witness, which is Ms. Cronje, as a magistrate, my Lord, when she was taking down exhibit recording in terms of Section 217, he recorded the statement in terms of Section 217, subsection 1B. But the case law, which is ACA that I've just referred this court to, says the requirement of Section 217 only is not sufficient.
No, of course not.
Yes, my Lord.
The Constitution, the whole Constitution is applicable.
Yes, my Lord. And then in this case, my Lord, I submit, my Lord, that above meeting the requirements, if they were met, of Section 217, the magistrate, who is the witness, ought to have explained the constitutional rights of the accused specific to the recording, to say that above what I will be recording, what I will be taking down in the statement, in the document, I will also be recording, and the voice recording will be used in court against you.
Yeah.
Those constitutional rights, my Lord, I submit that they ought to have been explained to the accused or to the deponent at that time before he made or before the witness proceeded with the recording. My submission, my Lord, is that as we are in a trial within a trial, until such a ruling has been made by this court, the video recording, which was unconstitutionally obtained in terms of Section 35(5), should not be played to the court because it contains incriminating evidence. My Lord, why I'm making that submission is because I have also listened to the recording. I have read the document that is in front of the court, which is Exhibit FF. JJ, sorry, my Lord, JJ. The state has also indicated, my Lord, will recall yesterday to say that they have realized that in the recording there is an additional information which is not contained in Exhibit JJ, and submitting the relevancy of leading the video recording. Hence, my Lord, I'm submitting to say the information or the evidence contained in the video recording is not the same as the document submitted before this court referred to as Exhibit JJ, if you listen to it, my Lord. As a result of that, my Lord, I will ask that we continue in a trial within a trial regarding the admissibility of the video recording first, and then after the ruling, the court then may listen to the video recording. Those are my submissions, my Lord.
Okay.
Yes, my Lord.
Yes.
Thank you.
So you don't want me to listen to the audio?
Not per se, my Lord, that we don't want, but we want the court to, the admissibility to be dealt with first.
Yes, yes, you're correct.
Yes, the manner under which this video recording was taken.
Yes, yeah.
Yes, so that for the court to disseminate on the admissibility. After the ruling, then it can be
listen
played.
to it.
Thank you,
If I rule that way, anyway.
Thank you, my Lord.
Okay, yes. Yes, Mr. Baloyi.
Can I just respond to one aspect that was raised by
Mr. Mngomezulu.
Mr. Mngomezulu and Advocate Mshololo, namely the lack of explanation of the rights. They seem to suggest that, and we're not conceding to that aspect. You know, they say if there's a violation of the rights in terms of the Constitution, the evidence should automatically be excluded. That is not the legal position, my Lord. There is that case of
Is that
Key versus Attorney General? Yes,
okay.
Where in the Constitutional Court, per Judge Krichler, at paragraph 13 held the following. In any democratic criminal justice system, there is a tension between, on the one hand, the public interest in bringing criminals to book, and on the other, the equally great public interest in ensuring that justice is manifestly done to all, even those suspected of conduct which would put them beyond the pale. To be sure, a prominent feature of that tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures and courts to prevent or curtail excessive zeal by state agencies in the prevention, investigation, or prosecution of crime. But none of that means sympathy for crime and its perpetrators, nor does it mean a predilection for technical niceties and ingenious legal stratagems. And this is what we want to emphasize. What the Constitution demands is that the accused be given a fair trial, and ultimately, as it was held in Ferreira versus Levin, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take the decision. At times, fairness might require that evidence unconstitutionally obtained be excluded. This is what they are arguing, but they did not mention the other side of the coin, where in the court said, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted. And there is the contention that we're making, that there's also the other side of the coin. Thank you.
Mr. Mngomezulu, any response to the Krichler judgment? It's a 1996 judgment, eh?
Yes, my Lord, it's 1996.
Yeah.
17 May 1996.
That's it.
I stand by my submission.
Yeah, well, the essence of that judgment is that although it sounds incongruous, because the general constitutional position is this, that like you quoted Section 35.5, evidence which is acquired unlawfully should be excluded and be made inadmissible. But Kriegler says there are instances where the dictates of fairness demand or dictate that evidence which is unconstitutionally acquired should be made admissible in the interests of justice and in the administration, in the interest of the administration.
My Lord, does that judgment of Kriegler,
Yeah.
it came in 1996. I think the decision of Magwaza, it came after Kriegler.
That's the Constitutional Court. That's Kriegler in the Constitutional Court. Magwaza is SCA.
But basically,
Okay, fine.
basically, my Lord, a right cannot be superseded by an element of fairness.
No, fine. I've heard you. I just wanted you to respond.
Yes.
Because you never, yeah.
Court.
Hobo, Mr. Minister, one bill. Are you responding also to the Kriegler statement? Ratio, that's even...
No, my Lord. I think my line of argument is
yeah,
not in
fine.
line what has just been
Okay,
proposed.
Mr. Ngumalo?
My Lord, my line of argument is totally away from the provisions of Section
Okay.
35. Yeah, thank you. So I have no
Mr.
response.
Mshololo?
My Lord, my submission is that the fairness cannot overweigh the constitutional right of the accused.
Okay, fine.
Constitutional right of the accused has been violated, my Lord.
Okay.
Thank you, Madam.
All right, is that it? So this court must now retire in order to consider whether the state has succeeded in persuading it whether the rights, whether the tape, audio tape recording is admissible, and consequently also whether, even if the rights of, if the rights of accused number 2 have been infringed, I should rule against the admission into evidence of that tape. Is that not what I should decide? Okay.
Inkantolo manje kufanele ukuthi iyothatha isinqumo ngoba ke izethulo ezenziwayo lana zenziwa ke kuyinhlangothi ezimbili umshushisi ngolunye uhlangothi ucela ke ukuthi le recording ngoba siyazi ukuthi udaba manje i recording ukuthi ke kufanele ukuthi ke yamukeleke na njengobufakazi noma ibe ingxenye yobufakazi kolunye uhlangothi ke abameli bona bathi cha lokho akufanele bathi futhi nenkantolo kufanele nje ingayilalelike noma ingayibukike manje leyo recording so mehluleki uthi ke manje kufanele ke ahamba uyothatha isinqumo emuva kokuthi ke sekwenziwe izithulo futhi be lethe ngaphambili ke amacala amaningi ke afanele inkantolo iwabheke nanjengomzekelo ukuthi ke ahambisana nesinqumo sokuthi ibheke abanye nesinqumo sokuthi cha ingayibheki inkantolo ithi ke manje kufanele uyothatha noma uyokwenza leso sinqumo leso.
Yeah, more especially that the facts in this case is the first time they are ventilated in a court, in a high court. Am I right, Mr. Mgomezulu?
That's correct.
I've read all the cases, all of them, starting from the 20s. It has never been a visitation of a court regarding the making of a recording of the pro forma question and answers encapsulated in terms of Section 217. Am I correct?
Yes.
Maybe you've read more cases than me. Yeah, consequently, I've got to really consider this decision carefully. Okay, so the court will adjourn. When should we reconvene? Because we don't have any other witness now.
Ms. Kronyesi and the interpreter, but we can
No,
make
she can't be cross-examined before.
alternative arrangements.
Yeah.
Yes.
You'll have to make arrangements. Friday, you were intending to do what?
Friday is tomorrow.
Yeah, you were intending to do it.
Yeah, well, we foresaw that
You saw
the
that
cross-examination might overlap to
the Tax
Friday.
Constable judgment.
I'm sorry?
That like Tax Constable.
No.
Uitspraak,
No. What we envisage is the two witnesses are waiting in the wings in case judgment is given.
What is that? Waiting in the wings?
They are just ready in case judgment is handed down. So if the court needs to consider judgment,
Yes,
there's
I
no
have to.
problem a lot. The witnesses will be excused until such time as we can reconvene.
Yeah, tomorrow. I've listened to all the arguments. Okay, tomorrow then at 10 o'clock, the judgment will be delivered.